guys, let's take a look at this Richard Allen case again in a little bit closer lens at the motion to dismiss filed by Allen's attorneys, largely related to the destruction of evidence by the state, particularly recordings of some people who the defense say are involved in the crime. So let's go over what the law is on that. There's been some confusion over that, probably because it is kind of complicated, and also nothing's really as clear as it seems to be on first glance. And there are people who think that, well, Allen should be in prison and all of this should be done away with, and he's certainly guilty, and why are we doing anything? And then there are other people who think, well, he's being railroaded, and therefore any and every single thing that his side brings up, they should definitely be granted. And if he doesn't win every single thing, then that's obviously all corruption. And the world's more complicated than that, and so is this motion. So I don't think this motion is going to be granted by for the defense, and not because of a secret corruption, but because it doesn't meet the legal standard. But it's still a good motion for them to file, in my opinion. And also the topics in the motion can come up later on in the trial when there are more facts that might support a sanction. Even if it's not dismissal, it could be a lesser sort of sanction. So it doesn't mean that you hear the end of it just because it gets brought up now and assuming that the judge denies it. But let's look at why I think that is likely going to be the case here, based on what I see as the law. And you may disagree, but if you do, I'd be curious as to what it is from a legal angle that you see. Anyway, let's get into it and take a look at a bigger part of the screen here so you can read it. So this is some of the memorandum of law there that the defense has put up to support their proposition that the case should be dismissed because the two interviews, the tapes, if they existed, I think one of them certainly did, they are deleted. They're gone. They don't exist anymore. So that's bad, obviously. If you're the defense, you want to potentially use those. Now, what is it that's on those tapes that you want to use? I don't think there's any contention that on either case, the person said, well, I'm actually the person who did it. And then the police wrote over that tape. So it's nothing as great as that. Or I was with Richard Allen that day and we were 600 miles away. It's not going to be anything so direct to Richard Allen as that, right? It's nothing about Richard Allen on those tapes. And there's nothing that the people are saying in the tapes that would make you think, well, they did it, at least not to my knowledge. So you don't have a direct line there. Instead, what the defense is saying, which is reasonable, is we're not going to know everything that these people said at that point. And since we think they're part of the crime, that's really important. And that's certainly good logic. They also say that we could potentially use these for impeachment later if the person wants to change their story or their story varies over time. And I get that too. But what you don't have, other than pure speculation, is the idea that something occurred in those hearings or those interviews that was directly related to being exculpatory for Richard Allen. That didn't happen. So I went over this yesterday, so I won't do it all again, but some of the cases cited here, and we'll actually look at those, because when you are citing cases for the proposition that a case can be dismissed based on state conduct, it's good if, in fact, in those cases, the case was dismissed, right? And if not, you may want to look more carefully at, well, why not? If that's what the rule is, why didn't it get applied that way? And how likely is it that the rule will be applied to the benefit of the defense? In this case, if the cases they're citing largely didn't get the result they wanted, which is the state of things. So we will flip down to the bottom of it. And I'm going to repeat this part here again, where it says it's beyond debatable that the evidence at issue here would play a significant role in Allen's defense. That is definitely debatable, because there's nothing on those tapes that anybody can say would have been directly exculpatory for Allen. It's all about, well, maybe these people would be inconsistent at some point, and so then maybe they'd be impeached by these hearsay statements. Yeah, maybe not too, right? And maybe you would have heard something on the tape that would lead you to something else about these people, but then again, maybe not. So, if the state destroys the evidence, it's not the case that the defense has to say, well, this is exactly what would have been in that evidence, but they are going to have to show why they think and how they think it links up to what they're saying they can no longer establish for the defense, and how that is super material to the case. It's got to be important, or at least I'll show you why that is the case. All right, so let's get into it. Let's summarize it before we look at the cases and put this in as easily understood terms as we possibly can. So there's a couple of categories here, this type of evidence that gets gone. And one is potentially useful evidence. Potentially useful. That sounds like a lot of things in my garage, right? That's what I tell my wife, that these things are potentially useful. We can't get rid of them, right? So this is not the best evidence on the planet, maybe, but it's potentially useful evidence. Well, if that's the kind of evidence that gets destroyed, then you need bad faith on the part of law enforcement before you're going to have this a heavy sanction occur. So if it's just something that's maybe marginal to the case or something like that, you gotta show bad faith, and that's a tall order. You're not going to be able to assume it. You can't expect the judge to buy into a hypothetical theory that the police are doing something bad against your client. You would have to show bad faith. The better category to be in, and the one that Allen's attorneys want to be in, although they say you can assume bad faith, but I don't think Judge Gold's going to do that, is material exculpatory evidence. Now, that sounds really important, right? Now, obviously, some of the things I said before could come into that category. Maybe a confession by somebody else, right? Or somebody else provides an alibi for Allen. Yeah, those things would be super exculpatory, right? Or they say something else that would really link them to the crime and steer it away from Allen. That could be in that category, right? It has to be material evidence, it has to be something on point and exculpatory. It can't be speculation. Well, we're never going to know what's on that tape, so let's just assume it was something that would be exculpatory towards Allen and throw this case out. It's not going to get you the results you want there. I'm sorry, it's not. And then the courts are also going to look at, well, okay, so if this piece of evidence is lost, depending on what you're trying to get from it, can you get it from something else? Because there are sanctions below dismissing a case when you have something like this occur. You could have a statement to the jury, you could have a witness excluded, you could have other states' evidence excluded, something like that. And the court's going to look at it and say, well, do you have access to this information in some other way? How important is it? And a hypothetical impeachment is probably not going to be viewed as material exculpatory evidence. That you might be able to show an inconsistency in somebody's story, maybe, and maybe not. That sounds more potentially useful than it does material exculpatory, in my opinion. Now, to be material exculpatory evidence, the exculpatory value has to have been apparent before the evidence was destroyed, and the defense is unable to obtain comparable evidence by other reasonable means. So was the exculpatory value of these interviews for Richard Allen known before these copies were written over, or whatever this alleged DVR defect was? Well, it kind of depends probably on a couple of things: what was said during those interviews, and then also when the deletion occurred or the mistake occurred. And if that was years and years ago, before Allen was on anybody's radar, it's going to be hard to say that it was exculpatory for Allen in particular, right? And I guess you'd make the argument, well, someday somebody would come along who gets blamed for this other than the people who did it, and they're going to want to be able to look back at these and pin it on these people. Would that have been apparent at that time to the police, that this would have been exculpatory to somebody else? I don't know. I don't think so. They maybe were hoping it would be inculpatory towards the people they were interviewing, but as to whether it be exculpatory towards someone else, what was said in those interviews, that's a little bit of speculation there, I think. And can the evidence be obtained by other reasonable means? Well, if you can get the story from these people from somebody else, or even the outlines of it, you've got some of that, you've got maybe all of it. And what you're hoping for is you could show some inconsistencies, but even inconsistencies doesn't mean that Allen is lying. And inconsistencies may or may not be admissible at trial because these things are hearsay, right? So they could come in potentially for impeachment, but that depends on what a person says at trial, even if they even show up at trial. And so that also means this could be brought up again by the defense later if it can be shown that this is more impactful towards the case than it maybe appears right now. It's not necessarily the end of the line, as I say. The defendant needs to show the exculpatory value. Now, it's obviously true that they get some leeway there if you can't understand all of it because the evidence is destroyed. But if the tape is destroyed of somebody who's an ancillary witness, and then you go, well, since you destroyed it, we're just going to assume it was super exculpatory towards our client. You're going to have the judge looking at you like, today's not your winning the lottery day, right? You're going to have to give me more than that, okay? So let's look at some of the case law and some of what's been said here, not anybody else's opinion on it, but what the courts have said, because that's the law in the state. So a defendant is not required to prove conclusively that the destroyed evidence is exculpatory, but there must be an indication the evidence was exculpatory. We will not simply assume that the destroyed evidence contained exculpatory material when the record is devoid of such indication. And I don't know that there was something on the tape that they don't know from somewhere else, okay, that was exculpatory. The only real thing maybe would be to have an inconsistency. But is there really some kind of information in there that would have pointed towards these people doing the crime that they can't and didn't find out some other way? Well, what is it beyond speculation? Take a look at what was said in this case. They note that they had held that videotapes of a defendant taking field sobriety tests were not materially exculpatory because the defendant presented no evidence that the tapes would show him passing the test, and asked us to speculate as to the tape's contents. Okay, so here you have a DUI case where they deleted the video of the person taking the field sobriety test. And you would think if you're the defense, then you would say, well, if you watch those tapes, Judge, you would see that they interpreted it wrong, right? That my guy was not drunk or whatever. But the court said, nah, we're not going to speculate on that. So even when they have a tape of the defendant performing the field sobriety test, they did not throw the case out. There was also this case here with a pager where I think they lost that. And then they said, well, we're not going to speculate if you might have run some other test on the pager that it might have done something else. You got to show us something. So you can see this is not a hair trigger by the higher courts to say, well, if something happens with a piece of evidence, then boom, the case is out. There's no hair trigger there. So let's move it on to some more cases here. Turnpaw v. State was cited in the defense brief. I think I mentioned this yesterday, but here's some language from it that you can read through. I won't read through all of it. But here we had a sexual assault kit, right, that was taken and then lost, okay? And it didn't exactly point to the defendant, but it was gone. And the defense says, man, we sure could have used that. How can you lose that, right? Because it's a sexual assault case and you lost the sexual assault rape kit, right? So, oops, sorry about that. The physical evidence comprising the rape kit were negligently lost by the police, the court says. The trial court denied a motion to dismiss the prosecution and the motion to suppress the state's test results, which is kind of interesting. Motions were based on the inability of the prosecution to produce the material comprising the kit for independent testing. Blah, blah, blah. Let's get over here. A serious breach of duty, and this is the language that the defense is quoting in the Allen case, occurs when the prosecution willfully or intentionally obstructs access of defense to material evidence in its possession. Now here, of course, it's destruction of evidence. And so that's the material things, because some of the things in the Allen case, they're saying the DA tried to keep it from us, but they have that stuff now. So it won't really be a strong basis to throw the case out. But the deleted tapes are something different. It's likewise a serious breach when, through a lack of vigilance, the negligent destruction or withholding of material evidence by law enforcement officers could create grounds for reversal. So in this case, due to its particular circumstances, there's no reversal. And they're talking about the limited evidentiary value of the kit. So you would think that would be central to the case, but the court is saying, well, there was other evidence as to who had sex with who and who didn't have sex with who, and the kit wasn't central to that, and they did not throw the case out. They say the prejudice to appellant's defense as a result of his inability to examine the lost samples does not have significance that would warrant this court in finding reversible error. So a main case cited by the defense in the Allen case another main case did not throw the case out while applying these rules for a pretty bad situation. Let's take a look at Berkeley v. State, another case that's cited. So this one was a situation where the attendant David Higgins was killed during a robbery, and defendant Berkeley and Smithhart were charged. And this is Berkeley's appeal here. So Smithhart's wife and Smithhart were brought together under law enforcement supervision in a private interrogation room that was being recorded by a video camera peering into the room through a two-way mirror. And then they talked to each other, right? And there's a microphone there. Then the prosecutor was informed by the police department, hey, we got a videotape of this. Then the DA realized, well, we didn't get anybody's consent. And so it's not going to be admissible. And then the DA looked at the tape and said, well, I don't think there's anything that would get either one of these off. It's not exculpatory. So let's erase this tape. And then Berkeley's attorneys found out about this tape and that it was erased. And so they moved to have the case thrown out naturally. That's not surprising. That's what the defense attorney should do in a situation like that. And let's see. But they're saying, well, there was nothing really necessary for this tape to be used for impeachment because the statements by Mrs. Smithhart, et cetera, they were consistent with what would have been seen on the tape. Because, again, it was hearsay, but it could have been admissible to impeach. But the destruction of the videotape did not preclude the appellant from using secondary evidence available to him for impeachment. And that the DA said, hey, there was nothing exculpatory on here. So on those facts, we hold there was no error in overruling the motion to dismiss, motion in limine, or his motion to strike. So see there, he did try a series of things. Hey, judge, dismiss it. Hey, judge, exclude some of the state's evidence. Hey, judge, strike this person's testimony. And those are all things you can try during the course of the trial and likely will occur in the Allen case too. Depending on how facts evolve during the trial, as you can see from this case, can impact the success of your appeal later on, right? If the judge were to turn you down because something could appear more or less material as the case moves along. Now, if there had been intentional destruction of something that's exculpatory, then it's a heavy burden on the state to show it did not prejudice the defendant. But in the Allen case, they don't have that. They have what is probably negligent. Now, I know the theory would be, oh my God, they did it on purpose. Well, if you can show that, then you're in the catbird seat, that's for sure. But I don't think they have the facts for that. All right, so let's look at another. There was another case where they did not throw the case out. Here's Cox v. State. And in this case, they did reverse it on other grounds, but they said, but you know what? We're going to go ahead and talk about an issue that may arise on remand because they're complaining about it. Cox argues he was entitled to a dismissal of the charges since the police had destroyed a tape recording of a conversation between him and someone else. And this was about stealing a sewing machine, I think, and something else. And he's saying, hey, on that tape, I said, man, I didn't know this stuff was stolen. You can have it and all of that. But the state says, well, you know what? You couldn't really hear anything on that tape anyway. So it wasn't worth anything. So then the court says, well, even assuming the tape was material evidence, we find Cox was not prejudiced by the tape's loss or destruction. Now, he said that the state bears a heavy burden to demonstrate non-prejudicial nature of its destruction. The state said he must show a substantial basis for claiming that this stuff is material in the first place by showing the evidence was capable of affecting the outcome of the trial. All right, so the negligent or intentional destruction or withholding of material evidence by either the police or prosecutor may constitute a denial of due process. There's an important word there called may. The burden of proving materiality is on the defendant unless it is self-evident or unless such a showing is prevented by the destruction of the evidence. Now, prevented by destruction of the evidence doesn't mean that because it's destroyed, you're just going to assume it was this super important thing. You're going to have to show logically how that ties up. Otherwise, the rule would be applied more mechanically than it is. All right, let's see here. In the instant case, the record clearly demonstrates the tape was inaudible due to the failure of the police to disconnect or turn down the volume of the police radio, and they couldn't understand anything on it, so they said, we're not going to throw this out. Okay. Now, they do say in here, in such instances, the burdens on the prosecution demonstrate evidence was not material and its destruction did not prejudice the defendant. So there could be some controversy over that in the Allen case, but I still think it's going to probably come down to the potentially useful side of things if you look at these cases. So the court looked at a couple of other cases of situations like this and said there were two Indiana Supreme Court cases at issue that are informative. Stevens v. State, a defendant was charged with murder, sought a dismissal due to prosecution's suppression of a tape recording his Miranda rights. He said, if you could listen to this tape, it would show I was too intoxicated at the time of the murder to form the requisite intent for the charge. And so therefore it's material and exculpatory. The tape was garbled due to a malfunction of the recorder. But since there was other substantial evidence in the record that showed his intoxication defense, the Supreme Court held the tape would be merely cumulative, even assuming its utility to the defense. And so it was not reversible error. And that's a little bit applicable to the Allen case. If they can show these guys had something to do with the crime, which they say they can, and they've never heard these tapes yet, they say they can show that, then it might be a cumulative situation anyway. Because again, those guys weren't confessing to the crimes in these tapes. You would have to go somewhere else to find that evidence. And then here's another one. Turpin v. State, the defendant alleged the loss of an exculpatory statement made by him to the police, saying it violated his right to due process. But it was not prejudicial since a police officer testified to the tape's contents. So the tape, if it was audible, would have been merely cumulative in Cox's case. All right. So you see the general tenor of these is they're not going out of their way to figure out how to throw cases out as the thrust of this. And here's Blanchard v. State, which shows up in the defense memorandum as well. This person says his due process rights were violated by the state's failure to preserve 27 photographs. He was charged, I think, with being responsible for the death of a child. And he says, well, if you would have looked at these pictures, you would have seen they were healthy and happy. The state picked out 3 bad ones and got rid of 27. And then that would have been materially exculpatory evidence showing the child's physical condition immediately prior to entering the hospital. The state says, no, these were at most potentially useful evidence. So you see the debate there, right? Because there's always going to be a debate. Is it potentially useful or is it materially exculpatory? Because which bucket it goes in decides the rest of the legal standards that are going to be applied. Since Blanchard failed to establish bad faith, the state argues his due process rights were not violated. So if it's only potentially useful and there's no bad faith, there's no reversible error. All right. The appropriate test to apply when deciding whether a defendant's due process rights have been violated by the state's failure to preserve evidence depends on whether it was potentially useful evidence or material exculpatory evidence, as those terms were employed in Arizona v. Youngblood, which is a United States Supreme Court case. So again, there's the 2 buckets there. I've got in the small text down here at the bottom is, well, what happened to those 27 photographs? He said, I picked out 3 I want to use at trial. I put the other 27 in a clear plastic shopping bag, put them on top of a file cabinet, on top of the file setting on the floor next to my desk. At some point, the cleaning crew came and took the bag of the photographs and threw them away. All right. So that's what happened to the photographs. That's bad. That's negligent. All right. Our United States Supreme Court has defined potentially useful evidence as evidentiary material of which no more can be said than it could have been subjected to test, the results of which might have exonerated the defendant. That's not a really good definition, or it's not particularly useful, is it? But in such a case as that, there has to be bad faith on the part of the police if you want a reversal. On the other hand, to rise to the level of material exculpatory evidence, the evidence must both possess an exculpatory value that was apparent before the evidence was destroyed and be of such a nature that a defendant would be unable to obtain comparable evidence by other reasonably available means. That's the standard we talked about at the beginning of this video. And then if that happens, the good faith or bad faith of the police doesn't matter. You don't need that as a predicate to getting a reversal. You would then enter into the rest of the legal standard. So that's the bucket you want to be in if you're trying to get your case thrown out. Let's take a look at, I think, one more. Lee versus State. He filed a motion to dismiss based on intentional destruction by the police of tapes containing interrogation of Lee, and this one was pretty bad, and the loss or negligent destruction of a 911 call by Richard Wilson, who was the guy who said, I did the crime, and they don't have the 911 call. All right, so let's see. The state says, well, there was nothing of any value or use on the tapes, but the tapes were destroyed because the police used questionable tactics during the interrogation that would be embarrassing if it got out. They cussed at him and they used some kind of religious stuff and all that. Accused him of bad behavior with his mother. And they thought, we shouldn't have done that. And so they erased the tapes. That's not good, is it? But they said there was nothing on the tapes of any value for the reasons stated above. And I think primarily because it's not like Lee said, well, I committed the crime or whatever, right? So it did show the police behaved badly, but it didn't show him confessing to anything. Now, Lee makes the very reasonable argument. He said, they say Lee doesn't point to any particular item in the conduct of the police that causes him prejudice, in that it destroyed exculpatory matters useful to his defense. His objection is that the police were bent on procuring his conviction for this crime, ignoring evidence that pointed to others who might have perpetrated it. He says the whole incident demonstrates the police were willing to ignore and destroy any evidence that might be helpful to him. And so it should be thrown out because it showed the police were willing to engage in intentional destruction of evidence. That's not that far-fetched of an argument, is it? Given the reason they gave for destroying the evidence. Now, again, it wasn't of someone else. It was a tape of him, but the reasons for destroying it were pretty bad. Then the other evidence that was destroyed in this case or lost or whatever, the second item was a taped 911 call by Richard Wilson. And Okay, so he didn't identify himself, but she knew Lee and James Burks. But he said he knew Lee and James Burks, and he had committed the crime. So this guy calls 911 and said, I committed the crime, and they don't have the 911 tape. They did trace the call, and an officer went there and found the guy standing at the pay telephone, the one who called the police to say he did it. So the dispatcher said, well, I recorded the call and placed the tape in the hands of a detective, but the cassette was never found after that. The trial court refused to dismiss the case on the grounds of this missing item based on the fact that Wilson, Anderson, and the officer dispatched to the restaurant all testified at trial for the defense and said, well, this is what he said on the tape. So they lost the tape, but they were able to get the evidence in through another means, right? So again, that's why it can be very hard to get a dismissal in early stage of the case, because you may have another method to get the evidence in that you're trying to get, and you need to explore that rather than hope the court will throw it out early in the case. The trial court found the loss of the tape worked no incurable prejudice on the defense, since the subject was reconstructed by all the parties concerned, and it was of minimal probative value. And minor inconsistencies in statements over several years could also be considered the same thing. So hoping that a potential inconsistency in statements over years is going to get your case thrown out by somebody who's just a witness, that's not going to happen. You're going to have to show something, I think, that is a substantial value that was likely on those tapes. All right, so let's go back to where we were before. So on the tapes at issue in this case, I'm not aware of any indication that it was exculpatory, or they should have known it was exculpatory for Allen at the time of the interview of these two people. I don't know that. I haven't seen anything that shows that at the time. And is there anything beyond speculation that it exonerates Allen? Again, those guys weren't confessing to the crimes at that point, right? Now, that doesn't mean there isn't information that could be useful to the defense on their course. I'm not saying that, but what is it? What's the sort of things that if you heard that tape, you'd be able to show those two guys did it, right? And therefore that supports your defense that they did it and not Allen. I don't know about that. Now, is it useful for cross-examination? Yeah, possibly. It can be used for impeachment if they come testify at a trial, and then if they were to contradict something that was in those tapes, but they weren't confessing in those tapes. So, some things that you change your story on, or your story evolves over time, matters, and some things don't. It just depends on how important it is. And that's kind of what I'm saying here with the parameters of the prejudice. Like, what was lost here, or what are you telling us was lost? And it can't just be speculation. And do you have other methods to get this information? And the remedies are not just dismissal of the case. They can include statements about impeachment or excluding witnesses and things like that. There are other things that can occur. And it also can be the case that as this case ever moves to trial, that the defense is better able to show, well, this thing was on this tape and it was super important, Judge, and it's not speculation now. Here's what's lost, right? But I don't know that that's going to happen. I think it's a good shot by the defense to give it a try. But I don't think it's going to win here, because I think this is more potentially useful evidence than it is the super material exculpatory evidence that you'd want it to be. And again, if you look at the wide variety of cases that are cited by the defense in their brief, and the outcomes of most of those cases are that the motion to dismiss was not allowed. And so, this is you're throwing a little bit of a Hail Mary to try and get it dismissed at this point. And I don't think the law is going to support it, whether you believe that's a conspiracy or actually the case, because all these cases were decided decades before Richard Allen was ever charged for this case, and they set what the law is. And so if you try and apply the law to this case, what's the conclusion that you probably would come to, which is, we're not going to throw it out here. I think the feeling of throwing it out is more sponsored by the idea that you don't think the case is very strong against Richard Allen to begin with. You just don't think the state has much on him. And that's understandable if you feel that way, right? But, if they had his DNA at the scene and you could see in the video it was him, and they actually got a picture of him leaving, and they got his license plate of his car parked there. If they had all the things that they don't have, and you could look at that case and go, this is ultra strong, and the defense says, yeah, but they deleted this tape of this witness who may change an element of their story years later. We don't really know, but that's possible. And so throw this case out. You would go, well, that's crazy, right? Well, in theory, you should do this analysis independent of whether you think the case against Allen is strong or not. You really should look at it on the value of the evidence that they're talking about that is the subject of this motion, which are those interviews. And that being the case, I don't think it rises to the standard that would cause this case to be thrown out. But then in my part of the conspiracy too, it's really hard to say, isn't it? Well, anyway, hopefully, at least whether you agree with me or not, you at least learn something about what the legal standard involved would be. And then we'll see how this gets ruled upon. And I'll talk to you later. Thanks. Bye.